Welcome to Tomkins Talks. It's time for a summary of another recent case in a short, snappy way that's easy to digest, whether you're at home, in the office, or on the move. Today I'm going to talk about the case of Bath Rugby Ltd and Greenwood and others. So let's get started with the backstory. This case concerns land in Bath known as the Recreation Ground and commonly referred to as the Rec. This land will be well known to lots of us, but particularly perhaps to rugby fans, as it's the home of Bath Rugby. The rugby club has a lease of part of the Rec and has wanted to replace its existing stadium for some time now with a new, larger stadium incorporating commercial outlets and associated car parking. The issue for the rugby club has been that there was a restrictive covenant in a 1922 conveyance of the Rec not to do anything on the land which may be or grow to be a nuisance, annoyance or disturbance, or otherwise prejudicially affect the adjoining premises or the neighbourhood. In order for this restrictive covenant to be enforceable, it had to be sufficiently clear to which land the benefit of the covenant was intended to be annexed. If it was sufficiently clear, then the benefit of that covenant would have passed with the land and could be enforced by its present owners. However, if not, then the covenant would cease to be enforceable. The rugby club considered that there was no one who could now claim to have the benefit of the covenant, so they made an application pursuant to section 84(2) of the Law of Property Act 1925 for a declaration that the Rec was free from the covenant. The club joined a number of other local residents who claimed the benefit of the covenant, some of whom owned properties overlooking the Rec. So what was the outcome? The matter was first heard in the High Court in Bristol. His Honour Judge Paul Matthews held that the covenant was enforceable on the basis that the 1922 conveyance annexed the benefit of the covenant to the land of the seller, as well as his tenants adjoining or near the Rec. Whilst Bath Rugby could not refer the matter to a television match official, they were able to take it to the Court of Appeal. And the court held that when considering whether the benefit of a restrictive covenant has been annexed to land, you have to consider the document to determine whether there was an intention to annex the benefit of it and something to define which land the covenant was intended to benefit. Here, the benefiting land was the neighbourhood. Was that sufficiently clear to identify the land that was intended to benefit? Well, the Court of Appeal's answer was no. The term neighbourhood did not enable a party to draw up a list of properties benefiting, and as such the Court of Appeal found that the covenant was not enforceable, which means Bath Rugby is free to proceed with its proposed redevelopment of the Rec. So what does this mean? When seeking to annex the benefit of restrictive covenants to land, lots of historic conveyances use phrases such as the adjoining land or the vendors adjoining and neighbouring land to identify the land that's intended to benefit. Now, whilst it may be that it's possible to determine the land benefiting from these types of phrases, parties looking to develop land, or perhaps prevent the development of land, may be wise to reconsider the wording of those covenants and whether the benefiting land is defined sufficiently clearly, as if not, the covenant may no longer be enforceable. So whilst it's been a very difficult season for Bath on the pitch thus far, this is some very welcome relief for the club. I hope you found this useful. If so, please comment, like or share this video. I'll see you again soon for another Tomkins Talks.